Now, this is going to be a mistake that she makes. She's going to make a conclusion of law. She's already concluded what type of court it is by coming in her opening statements. But we haven't have a determination on the record yet of what kind of court it is. And that's why you got to go in and ask questions. You know, asking questions is more skillful. Now, this judge right here, the reason I like doing this, because this is something you're going to run into a lot. He's going to stick strictly to the procedures. And if you're not going in line with their procedures, they're just going to ignore you and go and just run over you. Due process requires that they follow a step-by-step procedure, and most of the time, they skip over some parts that they're supposed to do, like proper service of process and giving you you have the right to know the nature and cause of the action, and they never revealed that. They used to reveal that on the announcement of the pleading, but they don't do that anymore because they're concealing it from everybody. So you don't have any choice but to go into the courtroom and ask.
Welcome to the Freedom Unchained channel. Yusef, one of the greatest true law mentors out there teaching right now today. So I want to bring you one of his videos. Chopped it up. It's one of his lives going over a sovereign courtroom situation, pointing out what's going on in the courtroom, what she did wrong, what she did right, what you should do, and helping you understand the process a little bit better. These are really good videos for you guys to watch. So go, if you guys haven't subscribed to his channel yet, High Impact Radio, go over there and check him out. He covers nature and cause, once again. That's one of the good things I like about him. He pointed out, made it make more sense to me than nature and cause questioning that you need to corner the judges with. I'm going to do a video about that and dive deeper into nature and cause and how and why that actually works. They're never going to admit it to you or admit that's the reason you won if you use it. Of course, they're going to use other reasons. So you guys all think you're still crazy. And Yusef covers that one as well. The subject of why and how the courts hide the truth. And he kind of talks about the same thing I just did in my last video, the wordplay video with Carl Lentz, how there's like two versions of the same word. There's probably a lot more versions than just two, but the government like to manipulate our language, the true language, into this false language, and has been in the indoctrination camps. This manipulation of the language that we have to deal with. One thing I like to teach about on this channel is pointing out the real meaning of words. So subscribe to the channel if you like things like that. Smash the like button. Leave a comment. Let's get a conversation started. Don't forget to subscribe to the Sovereign's Way Club if you haven't already. Start learning how to write your documents that you need to be writing, and the reason why you do it, and how to do it, and how to stand up as a man. Continue to listen to the people that I point out, like Yusef and Carl Lentz. They're both real big assholes like me, but they actually get to the point and kind of help you understand how to act and do business in this crazy world. But that's enough of that. Let's get going and start the video.
All right, peace to the gods, peace to the gods. Yusef here. I got a video review for you today. I have this sovereign video someone sent to me to review. I thought it was pretty interesting because the lady is in court and she's arguing some things that we all hear about. First of all, let me say this. I in no way consider myself the ultimate authority on any of this information. I'm just giving my opinion on something right now. No, there aren't any instructions on the proper way to do any of this written down anywhere. So, who's to say what is the right way to go into court? Really at the end of the day, all we can do is kind of study the law and kind of learn some things from some law principles and things like that and try to apply them when we find ourselves in specific situations. So in no way am I saying, well, she did this wrong, she did that wrong. It's just some advice on some things, and I'm going to give my reasons why, I prefer certain things over other ways in going into court. And I think this video is an excellent opportunity to do that. The individual who makes these videos, he's an attorney, and he gives his opinion on some things, and I don't too much I listen to it. I might have some differences of opinion. Sometimes though he's correct, because sometimes some of the things that people do in court is crazy. But you have to move with boldness. All I can tell you, you got to give anybody props that attempts to stand up and defend themselves in court. It's better than the person who just passively goes and does whatever he's told to do. Even if you're doing it wrong, at least, you're attempting to do it. You're asserting yourself. However, I cannot stress the importance of learning the information by heart so you can make it a part of you, because there are a lot of different techniques that you're going to see the judges use in here. One in particular is interrupting you. And it's easy to interrupt a person if they're reading from a piece of paper. They can lose their train of thought because they're having to concentrate and focus on what it is that they're trying to say. Versus when the information is a part of you, it's just you're just conversant with it. You don't have to strain or anything like that. It's just the information is a part of you. And that's where you want to strive to get to, at least to that point, whatever it is that you want to try to attempt when using any of these processes. Let's go.
Hello. It's Attorney Mike Gravelin, coming to you from Chicago as usual. We're waiting for our woman in common law who was held in contempt.
Good afternoon. We are in the 53rd Circuit Court for the County of Sheboygan. We are actually in the 89th District Court. This case is an 89th District Court case. We're conducting a hearing in the Circuit Courtroom. It's being clerked from the 89th District Courtroom that has participated by video conference technology into the hearing. And I am providing public access both in the courtroom and also online. So for that reason, we request that nobody would try to record or photograph anything during the hearing, as that can be disruptive to the proceeding. So we'll call the matter of contempt of Beth Michelle Bridgman. It's filed under the case of People State of Michigan versus Flores, filed 23-868SD. So Ms. Bridgman, if you want to come forward to the table.
I'm unable to do that. I don't have a license to practice law in the bar arena and in the water. I am a woman on the land, under the law of the land, and under the one true God. I'm a living soul.
Now, I'm going to take the time to pause and explain this to a lot of newcomers. Why is she saying what she's saying? Why is she saying I'm a woman and I'm up on the land, not in the water? And, I don't have a bar license to come across the bar. Why is she saying all this? Well, I agree with everything she's saying. It is true. Everything she's saying, she says she's a real woman. The courts only deal with artificial persons, which are corporations or corporate entities. Look that up. A corporate entity is a person. It's an ens legis, a creature of the state. She's saying that she's on the land, not on the water, meaning that she's under the authority of the Constitution for the United States of America, which is the law of the land for the public officials. And the water is the law of the sea, is admiralty. All right. Remember, when we go through these cases, we always want to go, now this is going to be a mistake that she makes. She's going to make a conclusion of law. She's already concluded what type of court it is by coming in her opening statements. But we haven't have a determination on the record yet of what kind of court it is. And that's why you got to go in and ask questions. Asking questions is more skillful. Now, this judge right here, the reason I like doing this, because this is something you're going to run into a lot. He's going to stick strictly to the procedures. And if you're not going in line with their procedures, they're just going to ignore you and go and just run over you. And this is why abatements are so important, because abatements go directly to the heart of the procedure. Due process requires that they follow a step-by-step procedure, and most of the time, they skip over some parts that they're supposed to do, like proper service of process and, giving you have the right to know the nature and cause of the action. And they never revealed that. They used to reveal that on the announcement of the pleading, but they don't do that anymore because they're concealing it from everybody. So you don't have any choice but to go into the courtroom and ask. And you want to get this on the record. For the record, Jana, is this a civil or criminal action? Well, it's a criminal action, all right? Or even what kind of contempt? Right here, they're asking, well, what kind? This is a contempt hearing. Well, there's never been any disclosure on the record if it's a civil or criminal contempt. What is the nature of the contempt? There's a criminal contempt, and there's a civil contempt. They just saying contempt, but that doesn't tell you what kind of contempt it is. It doesn't tell you the nature of the contempt. Same thing with a criminal action. Okay, you have a criminal action under the common law, and you have a criminal action under the admiralty, which is civil in nature. Okay, but it's criminal. Okay, so just saying this is a criminal action doesn't fully clarify to me what kind of action it is. So I'm going to ask you a question. You know, the Constitution for the United States of America only grants its court 2 criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Now, what I would suggest that you do is write down every word that I just said and study and look up every word. I'm talking about and, the, all of them. So you'll know it inside and out. All right, because the next video I'm going to do is somebody going into court attempting to do this, and they just screwing it all up. They're just screwing it all up, you know, and then they're trying to get out of something for the wrong reason. They didn't stole something from some people and did all this, and you trying to use these defenses to get out of trouble. You're a dishonorable person. That's one of the 4 rules. You have to stay in honor at all costs. But you acting dishonorably when you are out stealing from your fellow man. You got to understand, if you are sovereign, you operating under the laws of God. That's what you're declaring. You're declaring that the laws of God are going to guide me, are going to guide my conscience. So you need to declare under what, you know, are you a Muslim? Are you Christian? You know, what is it that, you know, what have you declared? What is your covenant with the creator of the boundless universe? What is your covenant with your fellow man? What is your covenant that you have with your wife? You know, everything operates on contract on the private side. So what contract have you made? Right now you have in the world, these people are trying to teach everybody to do what thou wilt, which is the thelema. Do what thou wilt. Operate under no law. God don't exist. Do what you want to do. This is demonic. A satanic presence has taken over, and it's a spirit that is pervasive all through the country, and you need to be acutely aware of that fact, and you need to start taking steps. You got to understand, you can't ride the fence. If you sitting there, you know, the creator of the boundless universe said, I'm going to spew you out of my mouth if you lukewarm. You either be hot or cold. You either be all right or you're not right at all. You're on the left or the right side. You're all right or you're not right at all. What is your position? Let's keep going.
And
Okay, I mean,
you're offered a contract with Beth Michelle Bridgman in all caps. I'm not that person. Anybody else in this room that person?
Hey, hang on.
Okay.
So, Miss Bridgman, you're correct that the bar in the courtroom, people have to be licensed attorneys to cross the bar to represent other people. Of course, people can and do, as you have, represented yourself on this side of the bar. So you're welcome to sit at the table there, which would perhaps be more comfortable for you. If you would prefer to proceed from where you're standing or sitting, that's fine with me as well. Do you have a preference then?
I'd like to stay right here.
Okay, that's
My
very
honor. I think the first matter I need to address is that I have a copy of your sworn oath here, and
I have to comment on that part too, where he's telling her, you know, about representation. Now, if you've ever been to court, you know you can't represent a corporation. An attorney must represent a corporation. But this is where it gets a little dicey for me, because they always try to make sure that you have a representation yourself, but they had conflict with the Constitution, because the Constitution under the 6th Amendment guarantees your right of self-representation. So if you assert it, they have to allow you to do it. But I don't think that they would prefer to. I think they always want you to have an attorney, because the attorney is the one that's actually representing the property, which is the all caps name, which is an ens legis, which is a corporate created entity. All right. So I just something for, you to think about. I'm just throwing that out there. I don't know if people are aware of it, not saying that it's right or wrong, but it's just something to think about. This is why attorney letters are so good, letters of instruction.
And
That's not relevant for today. So, Ms. Bridgman, you filed a motion for me to recuse myself. I'm going to deny that motion. It didn't present any basis for recusal. So that motion is denied, and we're here for a contempt hearing.
It's so much stuff I want to say on this. You know, she presented his oath of office, and he said that's not relevant to these proceedings. Now, that's a very interesting statement to make. I don't know if that just flew past people. I'm gonna rewind it and let y'all listen to that. You know, she said, I have your oath of office, and he said that's not relevant to the proceedings. Now, how is it not relevant? Is it not relevant because we're not operating under a constitutionally protected venue? You know, and if so, what is it? You know, is it a matter of contract, which is what it really is? It's a matter of contract. So it's in the nature of equity, and equity compels performance. So it's like, you know, that's the question. They make statements sometime and say things, and you got to be very acutely aware of what they're saying. He's saying that his oath of office is not relevant. How's your oath of office ever not relevant? You took an oath to uphold the Constitution for the United States of America. Now, here's the kicker, though. A lot of citizens of this country don't understand the true nature of the Constitution. The Constitution is public law. Anyone can get on the internet right now and Google public law, and they can see that the Constitution is included under that banner. So then the reason it's public law, because everything in the public has to do with government. So the Constitution forms government and it restrains government. It's a limitation on government. It enumerates what the government powers are, what they can and what they cannot do, what they can, where they can go and where they can't go. And we put a contract clause in there that stated they cannot infringe on the obligation of contracts. And they can't take property without due process of law and just compensation. And they can't come and pull you out your house at your private residence without a warrant. You know, just things like that. We're talking about public and private. We spoke it into existence. We're the sovereigns. We are their employers. We are their employers because we can fire them at any time by going up on Capitol Hill and voting them out of office. So we got to start acting like that. We got to start acting that way. But that's a very interesting thing for him to say, that his oath of office is not relevant to these proceedings. Let's continue.
Water. I am a woman on the land, under the law of the land, and under the one true God. I'm a living soul. And
Okay, I mean,
you're offered a contract with Beth Michelle Bridgman in all caps. I'm not that person. Anybody else in this room that person?
Hey, hang on.
Okay.
So, Miss Bridgman, you're correct that the bar in the courtroom, people have to be licensed attorneys to cross the bar to represent other people. Of course, people can and do, as you have represented yourself on this side of the bar. So you're welcome to sit at the table there, which would perhaps be more comfortable for you. If you would prefer to proceed from where you're standing or sitting, that's fine with me as well. Do you have a preference then?
I'd like to stay right here.
Okay, that's
My
very good.
honor. I think the first matter I need to address is that I have a copy of your sworn oath here, and
That's
it's
not relevant for today. So, Ms. Bridgman, you filed a motion for me to recuse myself. I'm going to deny that motion. It didn't present any basis for recusal, so that motion is denied. And we're here for a contempt hearing, which you've been arraigned on for your contempt for interfering with court process and the unauthorized practice of law, and then failing to attend the hearing.
this is
So,
true.
Ms. Miller, any opening statements?
Yes, Your Honor. I will share with you the evidence that Ms. Bridgman engaged in the unauthorized practice of law. That is.
Okay, I want everybody to pay attention. See how he just ran over her? Yeah, you know, I denied your motion. He turned it into a motion. I don't know. A motion is a request. So if it's a right, it's a demand. You know, you don't make motions when you are, motions also grant jurisdiction. If you're in there arguing jurisdiction and then you file a motion, how is it you claiming that they don't have jurisdiction over them, but you're going to ask them for permission? You know, so you can do things that'll kill your process. You know, you sitting here filing motions, and he construed it as a motion, and then he didn't give her an opportunity to respond. That's when she should have objected. Objection, Your Honor. Please tell this court and myself, how is it that your oath of office is not relevant to these proceedings? For the record, are we operating in a venue that is not protected under the Constitution? Because that's the only presumption I can make from your statement. Sir, pay attention to what they're saying to you. And then he just went straight over to the prosecutor And this is how they really do it. They all follow the same playbook. That's why I'm doing this. You'll see they all follow the same playbook. So this is why sometimes your stuff doesn't work. It's not that it's not true in what you're saying, is that you don't know how to handle this when they running over you. There's a document called the belligerent claimant. And sometimes you got to get belligerent with these people. They keep trying to schedule you for trial and you just keep telling them, well, I'm not arguing any facts, Your Honor. What I'm trying to come to a determination is I'm willing to take a guilty plea, but I need to know what jurisdiction I'm pleading into, sir. And that hasn't been made clear to me. Before I take this plea, I need some clarity on the jurisdiction that you're pleading into. And your answer hasn't been sufficient, sir. You call this a statutory jurisdiction. Now, I'm somewhat of a law library rat, and I went and looked for up this statutory jurisdiction, and I couldn't find one. Could you please tell me where I may find the published rules of criminal procedure for a statutory jurisdiction, sir? Do you have a copy of it? Do you know anyone who does have a copy of it? You must give it to me. How else am I going to properly, assert my rights in this venue if I'm not properly informed of the nature and cause of this action? And when it also make this whole entire proceeding eligible for judicial review at the appellate level, if you don't divulge to me the nature of the action? Just something to think about. But they're going to do that. So you got to be ready for that. And it's not easy to do if you're reading from a piece of paper. If you're reading from a piece of paper, you sitting there, first thing we need to do, Your Honor, we need to go to your, and you just start interrupting you and you reading and shit. Well, you just interrupt. Because you're going to get interrupted. That's a tactic that's old as all of this information. I'm not going to interrupt you too much. Start interrupting her over some bullshit. She's trying to make a record. And then he just told her what she's saying is irrelevant and then went over the old girl. And she said, you're right. I don't know what she was saying you're right to either. You don't ever admit to nothing on the record. She said, you're right about something. It kind of lost me, but let's get back to it.
Contrary to MCL 600.916, she further prevented the defendant in the underlying case from meeting with his MIDC attorney prior to his arraignment on November 30th, 2023, and she also failed to appear for her show cause on December 20th, 2023 at 11 a.m. Thank you.
All right, do you wish any witnesses sequestered?
I don't believe so.
Okay, Ms. Bridgman, now's the time you can make your opening statement to me, but first, do you wish to have any witnesses that will be presented sequestered, meaning that they have to leave the courtroom and be instructed to not watch the feed?
I'm not even contracted with this hearing, this administrative hearing. I cannot be adulterous to my own oath of office.
I'm going to assume that you're
put
rejecting
myself
my
under an
request for
authority.
sequestration orders and no sequestration orders entered. So go ahead with your opening statement.
Law is, must be a contract. In the absence of a valid contract, there is no law, period, which might be part of the problem that we have here. Now,
I don't mean to interrupt you, and I'm not going to interrupt you often during your opening statement. I do want you to know.
I'm not going to interrupt you often during your opening statement. He didn't say he wasn't going to interrupt her anymore. And then she said, all law is contract. See, that sounds like something regurgitated. It's like, you don't have to say that. When you're already asking them that question in the constitutional question. Yana, is this civil or criminal? It's criminal. Okay, thank you, Yana. Let the record show that the action being brought against the defendant is a criminal action. Now, sir, I have another question. The Constitution for the United States of America only grants this court 2 criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Now, sir, for the record, would you please tell myself and this court under which 2 of these criminal jurisdictions you're trying this criminal action? Okay, we already know it's a condition of contract or one or the other, but you didn't make a conclusion. You haven't found out on the record. You got to ask him first. Is this a condition of contract or is this common law? Is it a condition of contract? And if it is a condition of contract, I ask this court to please submit the contract into evidence and call the person who submits the contract into evidence with firsthand knowledge to take the stand and submit themselves to cross-examination so they can testify under oath how I am a party to said contract and how I'm obligated to perform under said contract. If we're going to go the contract route, the burden of proof is on he who asserts, not he who denies. And that is also the reason you're not going to see them testifying too much. They're going to let you talk yourself. They prefer you to talk yourself into a hole. That's what they want. They would prefer you to talk. But when you're asking questions, they can't do that. That's a guard against it. You know, anything you say can and will be used against you. If I'm asking you questions for clarification, which is what you should be doing anyway, because their entire system operates on a presumption. They presume you're presumed innocent until proven guilty. You presume to be a U.S. citizen. That's why they keep asking you on all them contracts that you sign. You're presumed to be amalgamated to the all caps name and be one and the same. These are presumptions. And you have to destroy those presumptions. So when you tailor or craft your presentation, it should address that. I'm the holder in due course. Here's a third-party intervener making a special appearance as the authorized representative for the defendant. I accept for value and return for value all the charge and instruments in this matter and make my exemption as principal available for discharge of all obligations and charges connected with this case. I'm not disputing any of the facts in the charge and instruments, Your Honor. Please use my exemption for offset and adjustment of the public charges against the defendant and release the order of the court to me immediately. You know, you say something like that, an opening statement like that takes care of it, severs that presumption that, you know, that you're tied to the straw man. It severs any type of presumption that you plan on going to trial. So we won't be scheduling any trial because I'm not arguing any facts. There's no need for fact finding before a fact trier. I'm not traversing the charges. I'm curious to find out the nature. Because if this is indeed civil, then I request that the Honorable Judge direct the prosecutor to provide the assessment for the charges, along with a certified audit trail of all the transactions, including vouchers, as well as all disbursement documents and receipts connected with this claim. Because it's civil, then we're dealing with a claim. And I could go into, do you have a claim against me? You go into court and ask them that, and watch how everybody gets silent. Do you have a claim against me? Do you know anyone who does have a claim against me? If the state of Georgia has a claim against you, Your Honor, I request the Honorable Judge direct the prosecutor to provide the assessment for the charges, along with a certified audit trail. Your Honor, I request that the Honorable Judge direct the prosecutor to take the stand and swear in. Because he had the claim, then whoever has the claim have to have an affidavit, because all claims have to be sworn to under penalty of perjury with full commercial liability. That's another thing she's going to try to use in here is giving him an affidavit. They don't never sign affidavits. That's how serious they are about affidavits. One thing they're not going to do is they're not going to lie to you. They're not going to lie to you, but they're going to obfuscate. They're going to throw all kind of things at you. But what they'll never do is lie under oath. They're not going to do that. They're not going to commit perjury because that's devastating to their career. So they're not going to do that. So, they're trying to find other ways to get you, but you're trying to corner them into that. You're trying to find a way now, they try to slip out now. Get back over here. Get back over here. We're talking about this right now. We got to get down to the nature of this thing. Because if this is civil, then it's you have some sort of pecuniary interest in the matter, which means there's some sort of debt collection or something like that. It's so where the presentment, where the bill. Oh, the bill of indictment? Oh, give it here. Can I get the matrix of it? Let me get the matrix of the indictment so I can satisfy this obligation. I willingly give you my endorsement on the obligation, and you can go ahead and settle the books and release the order of the court to me immediately. He's a hearing officer. I'm not here to argue any facts of the case. Y'all bankrupt entities. If this is a debt collection, y'all bankrupt. Y'all bankrupt. They bankrupt. They sitting up there. These are Federal Reserve courts. Listen, I want you to think for a second. They dealing in Federal Reserve notes. Federal Reserve notes are not constitutional in the Republic. Okay, they're stepping in court acting as if, okay, well, these are supposed to be lawful court processes in a lawful court, an Article 3 court. Because private individuals only subject, that's what Article 3 judges do. They protect private property and private rights of private citizens. They are the defenders of the Republic. But the Republic is a house no one lives in because everybody's using a social security card. Everybody is accepting benefits and privileges from the government. That's why you're being taxed to death, because you're only taxed on benefits and privileges in the public, dispensed by government. So the entire system is utilizing Federal Reserve notes, which is a benefit and a privilege. So that's why you're taxed every time you spend it. Every time you use Federal Reserve notes, they tax you on it because you're using a benefit and a privilege to set off debt using their corporate script. And their courts are accepting it. So if the courts are accepting it, the courts are colorable. Because for them to be lawful, they have to be using lawful money. Colorable money can't operate in a lawful environment. So it's a Federal Reserve system. And I'm here to tell you, I used to do foreclosure defense. The banks run the courts. I'm telling you that. The banks run the court. Everything is owned by the banks. They run everything. The Federal Reserve, because this entire country is a debtor country and it's indebted to the Federal Reserve. And the debtor can't give instructions to the creditor. And they dragging our country into the ground. They letting all these illegal aliens over here. They shifting all your jobs overseas. They didn't have any money to give these people in this hurricane, but you just gave $300 billion in Ukraine, came back, gave them another $150 billion, giving money over there to Israel. Their infrastructure all built up, and yours is dilapidated over here in the United States. And then you just bringing in, the reason you have immigrant laws, they got something called an immigration bond, okay? An immigration bond derives from the principle of the public charge doctrine. Google public charge doctrine and read the history of it. It was put in a public charge is you won't let people in the country that are not going to be beneficial to the country. If you're going to come into the country and be a homeless person, or you're going to come in here and be a thief or a murderer or something like that in some kind of way, or you're going to be a blight on society. That's called a public charge. And sometimes before they would let public charges in, they'd have to bond them. But what they just did is they just let them over the border just clean and free. All right, they didn't have to go through any type of process to come into the country. So now they're over here taking jobs. No money was issued in their name. So that's going to affect their economy because they didn't print any money. They have to print Federal Reserve notes based off of how many babies are born. But now we have 17 million people coming into the country and no money was printed to accommodate them. So that's a further strain on the system. And they don't care because the whole goal is to destroy the system. It's a new world order, and to create the new, you must destroy the old. Order out of chaos. That's their damn motto. They're creating chaos right now. So you can beg them for their help because they need you to voluntarily submit to them. They can't force you to do anything because they have to contend with karma. Even though you don't believe in it, they understand it. All these people, they are in some sort of order, whether it be the Masonic order, the Rosicrucian, Skull and Bones, Knights Templar. And they all, trust me, Rosicrucian, they all understand the 7 principles. Trust me on that. That's why they in ruler. That's why they in the position of rulership. Because those who serve on the higher rule on the lower. Those who understand the universal laws get to make laws for those who don't.
If you've gotten this far, you must be a true practitioner of true law. Or maybe I should say a dedicated practitioner of true law. So why haven't you joined the Sovereign's Way Club yet? I always leave a link in the description for you guys to join and start learning how you can become a man by understanding your documents, the process of doing business without having to take the government's form, and learn how to take your communities back by spreading this information and building your communities back up. That's the only way we're going to be able to destroy this communist idea. It's kind of weird that we got to use our communities to destroy communists. But the other cool thing about the Sovereign's Way Club is this Connect map. and go up here, hit connect. It's going to bring you into an interactive map where you can go to your location and find people near you wanting to be free men and women out of the control of the corrupt communist government. So if this is not another reason to join Sovereign's Way Club, completely free, you can join, get connected in the community, and then if you want to enhance your knowledge, you can go to knowledge and then dive deeper into protecting your family and your community with a small donation, which supports the channel. Let's get back to the video.
And Keith, you keep on saying the debt has already been paid. Ain't nothing been paid because ain't no money. Somebody came up with that prepaid. It's prepaid. Just say you're exempt from having to pay. We used the word exemption back in the day. You're exempt from having to pay for anything because you're the creditor. How's somebody going to make you pay for something they owe you? See, saying it's prepaid is confusing to me. It never really gives an accurate picture of the agreement or the arrangement. The arrangement is you took a gold and silver from the citizens. Okay, that wasn't taken without some expectation of return someday. You borrowed that. That money is in trust, and you're a fiduciary of it, and we're the beneficiaries of it. But we can't loan you all the gold and silver, and you turn around and then start demanding some sort of payment directly from us. That's why they made these straw men, because they're not contending directly with you. They're contending directly with another artificial entity. And that artificial entity you are in control of. You're the trustee and the beneficiary of that artificial entity. So you're exempt from having to pay. It's an exemption. I'm exempt. You can't require me to pay anything in any particular species or currency. You bankrupt. You $35 trillion in debt. And they're oppressing the people. That's why they acting like this. They trouncing America. Look at the national debt. They feel like they can do anything they want to do with this country. You $35 trillion in debt. United States of America, let me tell you something. Sometimes I want to stop doing this, but I see that I can't. Because the only way I see out of this mess is for y'all to go in there and start discharging it. Everybody in America need to send the Treasury Department a promissory note for the debt, because you go on the usdebtclock.org and say every citizen in the country owes about $96,000 apiece. Okay, where everybody in the country ought to write the motherfuckers a promissory note for $96,000 and tell them to zero out the account. That's the only way that I can see that we're going to get out of this mess, because all the taxes they collecting right now ain't even enough to pay the interest on the national debt. You $35 trillion in debt, you can't even pay the interest on it. And like the Bible says, the borrower is slave to the creditor. Let's get back.
That because of the way the video feed works, from where you're standing, it's not picking you up. And I assume that the audio is going to work through for the district courtroom that's clipping it. But
I'm content with all the people
okay.
that are here that
All right,
reside on the land that most of us call Michigan. If that's who is bringing charges against me and there is no person injured, there's no property damage, there should be no case. So my statement is that how can I put myself in your jurisdiction, except that you could do it by force and arrest me with 4 deputies with no due process and violate my unalienable rights to try to force me into your jurisdiction, because your oath of office.
Okay, it sounded like she reading something. She called it unalienable rights. There's something different from unalienable rights and unalienable rights. Okay, an unalienable right is a right that cannot be alienated from you, meaning that it is a substantive right. It is a right by nature. You couldn't get rid of it even if you wanted to. It's an unalienable right. I have a hard time pronouncing that word. I always had. Unalienable right. And then you have an unalienable right in the commercial context, because they use liens, and that's what a charge is. It's a lien. And they put in a lien against property to create money, because in their system, the creation of money is the creation through debt. So they have to have creditor and debtor relationships in order to create negotiable paper that has value that can be used as a medium of exchange and commerce. Because there isn't any gold and silver. And they're not using certificates of gold, a gold certificate or silver certificates, so they can't be redeemed for anything. So they're using negotiable paper that can't be redeemed for anything. So it's worthless pieces of paper. If it can't be redeemed for anything, where does it get this value? Only from the fact that somebody else will accept it. Y'all have to think, man. These people, when you say things like this, they come out in force to make it sound like somebody's talking to you stupid. When they the ones that sound stupid, because everything I'm saying is basic common sense. And they trying to make sure don't nobody have no common sense. They trying to make it where you can't even figure out who's a man and who's a woman. Let me keep going, man. Let me try to get through this. Thing is long. Let me get through this.
Is a violation of Section 5, United States Code 3001. You do not have an oath giver. You have yourself that signed it, and you have a notary. I just did an oath with the people here today, and they signed it, I signed it, and we got a couple of them notarized. That's how it should be. This is not a valid oath. I cannot stand in this court and be brought up because, in fact, you are operating or masquerading as a lawful court, but you're in fraud of the very oath that would give your court legitimacy. I have a remedy, Your Honor. I have an oath here, and if you would like to take it in the presence of the people and sign and notarized, we can move forward. Otherwise, I would be violating my very own oath of office and an oath I just took downstairs as well to the United States of America's Constitution.
All right, does that conclude your opening remarks?
Well, it concludes the fact that I see that you're not interested or care what the people and the truth of the lawful process of the people. I don't know if anybody else cares to say that. There's no injury and there's no property damage. I do believe I withheld Mr. Gilbert from some money he was probably banking on that day. And I believe the court operates in commerce and is here to make a profit on all of their activities. So that is my violation.
Okay, ma'am. You saying you believe it's operating in commerce. See, these are the type of things you can't carry into court with you. You can't carry this into court, man. Court is a place about evidence. You either can prove it or you can't prove it. If you can't prove it, it's hearsay. Okay? And a judge is under discretion to allow hearsay in. So this is once again where you got to come with the questions. You think they're operating in commerce? You got to ask some questions, some cornering questions. Well, you know, Your Honor, there's some things that are kind of confusing me about this whole thing. You're saying I'm here for a contempt hearing. There hasn't been any point where this court has disclosed the nature of the contempt, whether it's civil or criminal. So I'm kind of at a loss of exactly what type of punishment the court has jurisdiction to mete out if I am found guilty. Okay, so for the record, is this a civil or criminal action? And then I'm going right back into I'm always taking them back to the Constitution. Because he ain't answering the question. So if he doesn't answer the question and you don't hold his feet to the fire, on the record, the appeals court is going to look like you acquiesce to it. Sometimes you have to hit him with something 3 times. Do it and watch how shocked you are at the results. If you try to do something 3 times. Your Honor, for the 3rd time, I'm asking this court, or I'm demanding of this court, that you reveal under the authority of the 6th, I'm demanding of this court under the authority of the 6th Amendment for the Constitution of the United States of America, that you reveal the nature of this action. Let the record show that I have demanded of this court under the authority of the 6th Amendment for the Constitution of the United States of America for this court to inform the defendant of the nature of the action. And the court has failed in its constitutionally mandated duty to provide me with that information and now seeks to proceed against me under a secret jurisdiction that is known only to the judge and the prosecutor. Let the record reflect that. You're there to make a record because you can take it to another court. And the higher you go up, the more constitutional it gets. More eyes are on something. It's fewer and fewer judges the higher you get. More scrutiny. They gatekeepers at this bottom level. They get 90% of the people don't even appeal. I think it's like 90, I don't know how many, it's like 90% or something, 85%, some number like that, never even appeal. You're not the court either. The court is the paperwork. You're not the court. The court is the paperwork. Ain't no court without paperwork. You have a courthouse and a courtroom. The court is the paperwork. You're holding court on paper. Let's keep going.
State of Michigan hated that I blocked an attorney before Seth was arraigned. You cannot be bringing me in the hallway downstairs and charging me and then tell me that you're the true judge of the 53rd Circuit Court when your oath is not properly even administered. I happen to know, I believe, did you take a Bar Association oath?
I'm not answering questions. Are you done with your opening statement?
I guess I don't really need to be here because this is not a legitimate court that I should be standing.
You don't have to answer them questions unless you give them a constitutional question. You ain't asked him a constitutional question. He's following procedure. He's not under any obligation. He's not the one that's being tried, you know. So you asking him questions. You got all this right here. Like he just said, I'm not answering any questions. That's when I would have hit him with the Constitution, though. And you make the record, he don't have to answer any questions. But then when you hit him with something, you have a duty to perform. If you have a duty to perform and he doesn't answer questions, that's a problem. You got to attack their duty. What is their duty? You got to outline what their duty is. What is their duty to you? See, they not operating under, they're operating under a territorial jurisdiction. Okay, that means that the legislature has plenary power over it. What that means is you can't run to the other two branches of government. So you can't go to an Article 3 court and force an Article 1 court to do something unless it has violated something in the Constitution. And that's why they have procedures over there. And that's why they stick to the procedure. So you got to understand, you going in there, it's a procedural thing. Your mindset should be procedural and some sort of abatement. That's an abatement. When you want to reveal the nature and cause of the action, that's a procedural issue. All right, there should be some announcement of what type of the nature of the action before we proceed so I can know what rules are going to be applied. Police officers don't have to protect you because they're not the constitutional authority. The sheriff is. The police officers are armed security for the municipality. That's what they are. When the police arrest you, they take you to the sheriff. Ain't no police officers in the county jail or in the federal prisons. It's only sheriff deputies. If there's going to be some sort of restraint on your liberty, a constitutional authority has to do it. That's the sheriff. If you're going to be removed from your house, a constitutional authority has to do it. That's the sheriff. Police don't come and evict you from the house. And when you ask them, what's the difference between the sheriff and the police? One is city and one is state. That's the most ignorant answer. It's true. It's not wrong, but it's just giving you the bare minimum. The bare minimum, Let's keep going.
Be standing in, and I will not violate my own oath by submitting myself to an authority that has not done the proper oath himself.
All right, Ms. Miller, your first witness.
Thank you, Your Honor. The people would
Ms.
call.
Bridgman, you may not leave the courtroom.
I know you have people that need to know that they are violating people's unalienable rights by picking them off the street without a single piece of paperwork.
Okay, Ms. Miller, who's your first witness?
We would call
Does anybody else have a problem with this?
Oh.
Yeah.
All right, hang on.
Now, that happened to me one time. A judge told me I couldn't leave the courtroom, but it was how he said it to me. He said, hey, where you going? Where you going? I turned around and said, who you talking to? And he said, well, you're about to get a contempt charge. I said, that's going to be civil or criminal. And he got real quiet after that. And but the thing is that, you know, that's a real interest. You know, when you follow the orders of the judge, you know, sometimes you got to tell, you know, to be a sovereign, sometimes you got to test some of the things you hear people talking about, like they turn around and walk in. You know, we used to hear all that stuff. You know, they would come in, they wouldn't cross the bar, they drop the birth certificate into the well of the court. Here's the defendant, and then turn around and walk out, you know, and just do things like that. And I've tried a lot of those things, and a lot of times it didn't work. It didn't work. You know, I tried almost everything somebody told me, you know, because I wanted to kind of experiment with things. But then, you know, the more I studied, the more I saw that this was some sort of business going on in the court, the business before the court. You know, it's all commercial in nature. And I noticed that every time I was reading definition of words in Black's Law Dictionary, the words had dual meanings. They would have a common law meaning, and then they'd have a commercial meaning. But it'd be the exact same word, like the word presentment. You know, under the common law, it's a presentment of a grand jury. Under commerce, it's presenting a check for payment. You know, but they use the same word. And it happens a lot in the Black's Law Dictionary. A lot of times, it's like they got to overlay banking terms over common law terms. How they have hidden, it's ingenious how they've been hiding it from the public. It's ingenious. I already got somebody always coming on my, Yusef, could you please direct us to some courtroom success? Yeah, I already did 2 or 3 on this channel. Yes, it's courtroom success on video on YouTube. Yes. And I got it here on the channel. So go and watch them. Go watch him. Go watch all my courtroom videos. I got it labeled, he wins in court, sovereign citizen strikes back, something like that. Y'all trip me out when y'all think none of this stuff never works. Let me tell you something. I got somebody right now getting ready to sue the federal government for about $200 million. And let me tell you something. When you win, that's what you sue them for. All right? That's never going to hit the public record. The judge has already said it. I'm not going to make this a part of the record. So you're a goddamn fool if you thinking that you're going to go into the record and find evidence of this, because they're hiding it. That's why I'm doing these lives. Some of y'all don't have any goddamn common sense. It's called the occult world of commerce. Why you think they're going to make a public record of it? Where's your intelligence? Where's your common sense? Y'all think they're going to come through and just give it to you? Yeah, here it is. Yeah, we operating in admiralty, and we making slaves out of all of you. And, you know, you're right. You're absolutely right. This is a territorial, like they're going to admit that. When they throw out the case, it's never said, oh, well, you know, thank you, right. This is an admiralty jurisdiction. We're in the wrong venue. We're going to dismiss your case. They ain't saying no shit like that. It's going to be another reason. They're going to hide it. The actual reason they let you go. And when you start doing this, you're going to start seeing when they back up off of you. This is the type of process you can only find out when you do it. Ain't nobody you can do this vicariously to through somebody else. You might every now and then catch a video on YouTube where they win some shit. But 90% of the people going into court don't know what the hell they doing anyway. That's why they put it all on the court, in the internet. 99% of the people trying this don't even understand what they're doing. And I'm going to do and let me tell you this. I'm going to do a webinar with the girl who just won this $200 million case. I'm charging $1,000 a head. And I want to see if you heads out there, you want so bad to see proof and everything, if you're going to pay that money and come. That's how important it is, where I'm going to charge $1,000. And I ain't never even did that. But because she got the pleading and that they took off the record. And it's going to cost you some money just to see it so you can know. Because we got people like that always talking about, you know, direct me with somebody who won this case. I mean, that's just the most idiotic shit ever. I don't know why in 20 years, that's why they keep on saying that, like, oh, well, ain't no record this ever won. Yeah, the people who win, if they get money, they not telling your ass. Ain't coming all on the internet. You think they're going to let somebody come all on the internet and say, okay, we just sued the federal government, got millions of dollars because they violated our rights? That's not happening. That's not happening. They not revealed. They got a whole system in place to keep this under wraps. And they've been doing it for a very long time. That's why you have to have people like me come on and point things out for you to see. Because the way the attorney is going to interpret what happened into the courtroom, I'm not going to interpret that way. That's why they got all these narrators on YouTube saying sovereign citizen fails in court, and they narrating it for you so your mindset will think a certain kind of way of what you're seeing. But because I done been through it already, I don't see that. That's not what happened. That's not what happened. That's not what happened at all. But you're going to look at it because you don't have any information. And you're going to make an interpretation based off one of these guys on the internet, one of these plants that they put on the internet. Let me tell you something. If you don't think that they got people in the chats, my website is down right now. This is the second time in 2 weeks my website went down, and I gave no explanation why it's down. And it went down right when I got planning to throw a webinar. And they said, well, sorry. Okay. What I was saying earlier, stop asking people for proof on the record. These things get settled out of court. When you win, it's not going to be on the record. They know that too. That's why they always come and ask you, well, show us proof that this is on the record. If you win, they're not putting that on the record. Let me tell you something about that. Transvent versus the city of Tampa. Okay, it establishes a calculation for how much it costs for holding somebody in jail illegally and unlawfully. Okay, it's $1,000 an hour. It's $1,000 an hour. This person got held 800 days in jail. Like when you see guys that get like 24 years in prison and then they come out and then they were found innocent. There's a guy that got 45 years. All right, and they came out, they threw him $750,000 or $2 million. I seen $2 million. Let me tell you something. If you do that much time in jail, you ain't supposed to get nothing less than $200 million. They chumping them people off big time. Throwing them $2 million. You ain't supposed to get nothing less than 200 million, 300 million for something like that. You don't sue them for nothing less than that. If they're going to lowball you, make them lowball you for 40 million, 50 million, 70 million. And you think that those cases are going to get publicity? See, this is what I'm saying about a lot of people in this space. You got to be careful of the people that are in this space because a lot of them don't think very common sense like it's a lack of common sense to think they're going to admit something on the record. They don't ever admit anything on the record. That's why I'm sitting here telling you how to, these are called cornering questions. You have to corner them where they have no choice but to tell the truth or dismiss the case. That's the whole purpose of asking questions. Because when you watch Howard Friedman's the UCC connection, that was the point in there that he said. He talked to that judge. That judge said they can't ever reveal the jurisdiction that they're operating under. They can call it whatever they want, so they choose to call it a statutory jurisdiction. Now, some of you have been in court, and they said that to me. And when a judge said that to me, I laughed at him, and all the charges went away. I laughed. I said, what did you say? He said, it's a statutory jurisdiction. When they say that on the record, you won. Because how can they commit an action to a jurisdiction that don't exist? The jurisdictions are carved out in the Constitution. I don't see the word statute nowhere in the Constitution. Statutes operate in a legislative framework. In other words, what the legislature and their delegation of authority, what they have authority over. And that's all. The powers that are enumerated under Article 1, Section 8. And so now we have to contend with Article 1, Section 8, Clause 9. Because that's not listed under the judicial branch. It's listed under a legislative branch. So now we have evidence right. Okay. Let me say this. One last thing, because obviously I don't know what's going on with the sound, but I'm going to get this last message in. Listen, you got to understand this information. Them people who be all in the chat talking about, well, they show me evidence of this work. They ain't got it set up like that. They don't have it set up like that. It's not set up where you can go get proof and just show all your friends and things like that. They don't have it set up like that. They got it carefully crafted where the only way you're going to find that is you got to go through it yourself. And that's why this thing, I don't understand why people, listen, if it didn't work, it's just you failed. You just failed. It's not that something wrong with the process. It's just you don't have what it takes. This ain't made for everybody. You got to have a certain kind of character to make this stuff go. It ain't something you just write on a piece of paper and go into the courtroom and just say. That's y'all problem. Y'all think there's some sort of magic paperwork and magic words somewhere in existence instead of understanding that you have to embody your rights. You have to embody the truth. It's not something you just regurgitate off of a piece of paper. And that's what you think. And that's how y'all approach it. That's why you've been, well, show me if I say this, it'll work. No, you're supposed to know. You're supposed to already study to a point where you know what to say when you go into court. Can't nobody tell you that you right or wrong. You understand what's going on and you know what you need to do. Fuck what the next person say. Fuck this. Because I'm telling you, the people who ask me, show me proof, they the dumbest people. Because they ain't got common sense. I mean, like, what you talking about? Show you some proof. What, you think the people gonna admit it to you? That's what you think? It just amazes me. Why do you think this has been in existence for like 50 years? There's track records of people going to court with like 50 years. You think just everybody just crazy, huh? We just all a bunch of loons. That's what they're really trying to say. What they're really trying to say is that you're proselytizing some type of information. You're some sort of sovereign citizen nut job that's proselytizing some information that doesn't have any track record of ever winning in court. That's what they want you to think. But I'm here to tell you that majority of the people that are participating in the public, they dumb as hell. They on drugs. They just fall in the script. If you take them off script, they don't know what to do. They all fall. They have a ministerial duty to perform. And they don't even learn constitutional law in law school. None of this stuff. And let me tell you, you go in court, you'll find out for yourself. And when you find out for yourself, won't nobody ever be able to take that from you. It doesn't matter what somebody else say. You'll be looking at this thing, man, shut the fuck up, man. I've been in the courtroom. What the fuck is you talking about this? Talking about this don't work. No, it didn't work for you because you probably got in the courtroom and froze up. Your left nut dropped out of your nut sack and it didn't work. That's what happened. Tell the truth. You wasn't prepared. They hit you with something you couldn't answer. They ran over your ass. They railroaded you. And you sat there and let them do it. Don't come back and say, well, this ain't true, it don't work. That's why I'm doing this, because one thing I respect about this woman, even though she might not have all the answers or whatever, I respect her courage and her heart. All she needs is the right information to put on top of that, because she already got the character. She looking for a man to stand up and come to her aid. She's standing up before a woman. It'd be some man, somebody who mess with that. I ain't mess with that judge. I like that. Let's keep. All right, I'm going to try to get some more of this in. Let's see if we get some more.
Tyrannical police measures.
Yes.
Did you tell me what Officer Dukowski said when he pulled you over? What was the reason he pulled you over that night?
He did not state a reason.
Was it something about a Butler Road in what I could recall?
I believe he told us, or the driver, my friend, that he crossed the center line.
I believe you had told me the white line.
Yeah.
Okay, she didn't let these people pull her into a trial. When you get in a trial, you totally in their jurisdiction. Now, here's the funny thing. The girl I'm talking about who won her case, she asked them for the nature and cause of the action. They didn't tell her. The judge ran over her. She took it to appeal. She got it on the record. She got everything on the record, took it to appeal. It took almost 2 years for her appeal to go through. They remanded the case back. They forced her into a trial and she won. She won the trial. Okay. The paperwork on the appeal is what is killer, but she won the trial. Now, I didn't expect her to win the trial because if for her to win that trial, they'd already held her 2 years in jail. They got to pay you for every hour you was in jail. So the judge said in the hearing that we can't make this a part of the record because of sovereign citizen ideology. She actually said that. We can't let that in the record. I know I'm right. I know I'm right in what I'm saying. They hiding it though. So what I'm here to do is simply to tell you what to look for. Because here's this is what they don't do. Tell us how many times you won with an attorney. They always talk about this don't work. They got a 98% conviction rate on the federal and state level. I ain't never seen no attorney do anything other than file a motion for bond, maybe a motion to suppress, and then come right in your face and start talking about a plea deal with you. And then if you don't take that, he out. But he won't come over and criticize what we talking about. But you expect us to take that right and then pay the man $20,000, $40,000, $50,000 for that and never ask him for your money back. But you'll try to get a refund from me for $49.99. Get the hell out of here.
A white line, which is not the center line. And there are no white lines out there on Butler when you turn off. How far did Deputy Dukowski follow you that night?
Your Honor, I guess I'd object to the relevance of the question.
I'll overrule it. Go ahead and answer the question.
From Subway to Butler Road. They said that we crossed the line by Subway, but I don't recall.
Okay. I recall you, and listen, I know this was a high stress environment for you, okay? And I have many friends in town who have gone through this
Your Honor,
same thing.
I guess I object
And
again
so-
to the question.
Well, I think she's laying the groundwork for a question. Go ahead.
Because-
You have to end up at a question.
If you've gone through 3 years of COVID in the schools and complied with everything, you're very compliant. He did comply with me. I offered him liberty. You offered him, maybe Dukowski talked about taking his vehicle. Is that right? Are
Yes.
those the terms you had told me?
Yes.
Yeah. As a passenger, did you really have to surrender to all those things that you?
Okay. I'm not going to listen to the rest of this because she went into a jury trial. And once you do that, anything goes to that point, because you're not supposed to ever get to a point where you're in a trial with this information right here. None of this private information is meant for a public trial. None of it. But I will say this, you should be prepared. If you find yourself in a situation where they're forcing you into a trial, even after you have said on the record, I'm not, because you got to think about this, how they take you to trial and you say you're not arguing any facts. That right there lets you know you're getting railroaded because you're not arguing any facts. So they say, well, okay, you must going to plead guilty. Well, yeah, Your Honor, I don't have any problem pleading guilty to the facts, but I need to understand what jurisdiction I'm pleading into. And this court hasn't revealed that yet. So you got to always take them back to the Constitution. They got a lot of little nice little ways because people have been doing this for so long. They got together and they be discussing all of this shit. And they come out with ways to counteract with what you're doing. But there's some questions they can't never answer. And one of them is, ain't no person, I guarantee you, we could have 50 attorneys in the chat, 100 judges, and all their little lap dogs that be with them in the chat room, and not one of them will go on record and answer these questions that we're talking about. I ain't never seen it happen. But they got all kind of way. And this girl right here, she took their ass all the way. And I was shocked she won. I was shocked. It was a hung jury the first day, and they came. And really what saved her is that they only had one witness, and they impeached his evidence. And then it was outside the statute of limitations. They didn't have nothing. They didn't have no choice. And she'd already taken them to the appellate court. That judge wasn't going to get remanded again. That was going to look bad on her record. They had no choice. So they're going to offer some little bitty amounts of money or something like that. Because you done held somebody in jail 2 years. And then the judge says something slick like, well, you already did some time. They'll say some slick like that. Well, you already lost. You already did the time. They'll say something a little nasty to you like that. That's when you make their ass pay. You make their ass pay. You right, I did do 2 years in jail, but you finna unask this money. I'm gonna live the rest of my life on your dime. And your boss gonna be looking at you sideways because you was the judge that let it happen. Or the administrator. Yeah, I know, man. I did this a long time. I've been doing this a long time, man. I've seen all kind of stuff. I don't be paying attention to them people because one of the things they number one goal is to make sure you can't find any proof. And when somebody win, I just saw what happened. I was like, damn, they said, okay, we're going to take this out the record. Strike that out, and I say, no, we can't let that into the record. I asked, I said, you got a copy of it? She said, I got a copy of it. I'm taking it to the people, but that's some valuable information because it's going to help somebody get out of jail. And you'll throw an attorney $20,000, for some, you got to understand, you got to stand on the and here's the next thing you have to do, because this is the next problem. This is the major problem. You got to still start living your life in conformance with what you're saying. You know, you can't sit here and say that you sovereign, you're a private individual, and you steady taking benefits and privileges from the government. That's what the Ashwander rules is all about. You got to understand equity is not going to allow you to do that. You can't take a benefit and then deny the corresponding liability that is attached to the benefit. There's a liability attached to any benefit because there's no such thing as something for nothing. There's a cause and effect for everything in creation. There's a push and a pull, an in and an out, a up and a down, a light and a dark, a hard and a soft, a long and a short, a public and a private, a guilty and an innocent, two sides to everything. So there's a flip side to what you call free, which that's a word they made up because the only thing that exists is exchange. Your air is not even free because you got to exchange carbon dioxide with the plants so they can give you oxygen. All right, so yeah, I thought, I didn't review this. I didn't know it was going to go into a trial like this. I got another one. Let me see if I can cue up the other one.